Hi guys, Jonathon Daily from Daily Law here. Are you a landlord dealing with a non-paying tenant? Well, if you are, this video is for you. We're going to start from the very beginning to the end of the process, what you should do with some nuances in there in between. So if you want to hear how to handle a non-paying tenant, please stay tuned for this video. What do you do first? A tenant's not paying, you haven't had a communication from them as to why they're not paying. Well, if that is the case, we're just gonna go ahead and hit them with a 3-day notice. In Florida, a 3-day notice to pay or surrender possession of the premises. What this does is it puts you on the offensive. You're able to immediately file for an eviction after this. So I'm just gonna walk you through the process of how we would do it in St. Lucie County. If you're a landlord that has 3, 4, 5 properties, not a big landlord, then it may be easier just to do this process yourself instead of wasting the time and energy to hire an attorney. However, if time is money to you, you've got 20, 50, 100 properties, then just hire an attorney to do it. I'm telling you, you'll be worth it every time. The process, hire an experienced attorney in your specific county who understands the judicial process in the county and understands the judge who handles the evictions. In most counties in Florida, evictions are almost always handled by only one judge, sometimes two. So I'm going to give you how we do it in St. Lucie County and the Martin County, the surrounding counties, so you can make the best decision for yourself if you're from those counties. If not, then you definitely want to go review. The process is similar. It's almost the same in every county in Florida, but there are some nuances and some specific things in each county that it may differ and vary based on each judge. One of those things that could vary, for example, in Martin County, if you're filing eviction, whether you're doing it pro se or you're doing it with a lawyer, they require an affidavit of ownership or you to attach proof of ownership. Not necessary in St. Lucie County. As long as you're an attorney or you're alleging that you're the owner, then typically they're not going to require you to have an affidavit or proof of ownership. Some counties also require a non-military affidavit. Some counties like St. Lucie County don't necessarily require that. As long as you're alleging that in the complaint, that is enough. So, like I said, these are just an example of the nuances between certain judges in certain counties. Some may not just grant a final judgment without a hearing if you don't have those documents in play. So if you're struggling to get that final judgment and you're not sure why and you can't get connected with the judicial assistant, give us a call or give a local attorney a call and they probably can know what you're missing. So in St. Lucie County, which is where we handle 75% or so of our eviction cases, this is the process. We do the 3-day notice. The 3-day notice says you've got 3 days to pay or surrender possession of the premises. What happens after these 3 days? And it's important how you count these days. If you serve them on a Friday, those 3 days, you do not count the weekend. You don't count Saturday, Sunday. So Friday, you don't count the day that they got it. That means they have Monday, Tuesday, and Wednesday. So when Thursday rolls around and they have not paid what they owe, what you put in the 3-day notice, make sure to put exactly how much they owe. If Thursday rolls around and they have not paid what they owe and they have not surrendered possession, Thursday you can file the eviction complaint. The timing is important because a savvy attorney or some of these tenants who have been evicted several times and they know the eviction laws because of that will use that as a reason to do a motion to dismiss or make some sort of argument. Now, you might get lucky and they don't pay rent into the court registry and you'll still win despite this. However, it's important to try to follow the rules and the law if you possibly can, because procedure is what is going to kill you in these eviction cases. And if you're doing it yourself, as you know, time is money. Getting them out as quickly as possible is the goal. So you've done the 3-day notice, you served them on Friday, the next week, Thursday rolls around, they haven't surrendered possession, they haven't paid you the rent, you go file an eviction complaint. It's probably best, if you've never done it before, to just go to the clerks, tell them you would like to file an eviction, they'll give you an eviction form. They can't help you fill it out, but they can tell you what form to use, and it pretty much is self-explanatory. Fill it out, make sure you put how much they owe, that's specific, what rent is owed, how much is owed, and what type of notice that you gave them, and make sure those are correct. Because again, if the tenants tenants are savvy or they have an attorney that knows what they're doing, they can make a good argument that you didn't provide the correct notice or allow the correct time period to pass, whatever the case may be. So make sure those are important. The rent amount, type of notice that you used. So here in this example, we did the 3-day notice. So therefore you put they owe this amount rent. So they had $2,500, $4,000, $4,500, and you sent them a 3-day notice on X date and attach the lease to the complaint and notice that you sent them the 3-day notice in this case. Filed the complaint. Very important. You also have to fill out a summons. So that's why if you're at the clerks, they probably will help you with that, but make sure you do a summons and complaint. Once you have successfully filled these out, have them served. If you want to save a little bit of time, hire a professional process server, ask an attorney in the area, or just do a Google search and try to use ChatGPT and find a process server in that area, in that local county, and get them served immediately. If you can have them served in person, that means they knock on the door and the summons and complaint for the eviction to get physically handed to them. They are personally served under law. You're good. They have 5 days to respond. Important nuance here, and you should just go ahead and do this when you're filling out the complaint and summons at the clerk. Go ahead and do a certificate of mailing with the clerk. The reason for this is because under Florida law, if you have them served, and a lot of times tenants know that an eviction is coming, right? So they're not going to answer the door. This process server you hire, or if you use the sheriff, it takes a little bit longer that way, but a lot of people just use the sheriff. It's usually a little bit cheaper. The tenant's not going to answer the door, so they're only going to be able to serve them, not personally. They're not going to physically hand those papers to them. They're going to post it to the door. If this happens, you can't get a default judgment unless you did the certificate of mailing. The certificate of mailing, like I said, is something you can do when you're at the clerk's office. Ask them to do a certificate of mailing. They'll give you the form. Then you just pay for the postage, a couple bucks, and they will print out the complaint that you filed and the summons, and they will physically, the clerk, that means the court, will physically mail the certificate of mailing to the tenant at that address of the premises that you're evicting them from. The reason for this law is kind of common sense if you think about it, but what they're trying to avoid is just having a landlord not give a tenant proper notice, slap a complaint and summons on the door and take a picture of it and take it down, and not really give the tenant notice that an eviction's happening. So at least this way, the clerk themselves is saying, we are mailing it, and that's what the certificate says. They are certifying that a physical copy of the complaint and summons was mailed to the tenant at the premises that they're being evicted from. And if that happens, so they're personally served, right? That begins the 5-day countdown period. If they're not physically served, you're just posted, then it's either 5 days from the posting or 5 days from the certificate of mailing, whichever is later, whichever gives the tenant more time. So that's why I said it's smart to just go and do the certificate of mailing when you file the complaint. That way, if your process server or the sheriff who's serving process is not able to personally serve them, then at least in that case, you've already done the certificate of mailing. You don't have to make another trip to the clerk and delay the eviction by a couple days or even a week. So what have we done? We've done the 3-day notice. They didn't pay on time. You counted the days correctly. Then you've done the certificate of mailing. You've done the complaint. You went to the clerk on the Thursday. You did the complaint, the summons, and the certificate of mailing. All that's been sent out. You had a process server try to serve them. They posted it, but you already did the certificate of mailing. All this was done on that Thursday that you filed. So now how do we count? Well, if you did it on a Thursday, let's be honest, the certificate of mailing and the process server at earliest is probably going to be that Thursday or Friday. So if they are served with the complaint and summons on that Friday, or you did the certificate of mailing, so it'll be that Friday either way, then you count. And again, if it's under 7 days in Florida for not just evictions, but anything that is a time period under 7 days, under the rules of judicial administration, you don't count the weekends. So if they were served on that Friday with the complaint and summons, you don't count the Friday, you don't count Saturday, you don't count Sunday, then you start counting on Monday, Tuesday, Wednesday, Thursday, Friday. So by the next week, next Friday, if they have not responded, then at that point, the following Monday, the courts are closed, then you can move for default. And again, if there's any holidays during that time period, those do not count as well. So it's important to know how to count. Once that next Monday, assuming there's no holidays or anything hits, that's when you can move for a final default judgment. And this is really important, and this is where the specific counties come into play. Go search the judge, because you'll be able to tell who the judge is based on the docket, and the clerk, when you file, you'll just ask them who the judge is. Go do a search on the judicial procedures for that specific judge. And at least in the 19th Judicial Circuit, which is what we practice in, there's a 19th Judicial Circuit website, and that has all the judges, and they have a specific web link to their webpage, and that's where you can find their procedures, and that's where you can, Control F, search evictions and read if they have a specific procedure for their evictions. And a lot of times these judges have specific requirements in order to get a default judgment for possession over the tenants. And that's again where an affidavit of ownership and a non-military affidavit can really come into play and be important. And again, St. Lucie County, Judge Alonzo, at least currently, it's sometimes easier to get a final judgment eviction. And again, this is where it can come into play where it's just better to hire an attorney, because attorneys who have been in front of that specific judge and know exactly what their procedures are, the judge is much more likely, not necessarily to just skim over everything and grant the final judgment, but they're much more likely to be like, okay, I know this attorney, I know they're legitimate, and I know that they've done 100 evictions here before. So it looks like they've got ABC, they got all the documents, the notice, the complaint, they've been served, no response, no payment in the court registry, boom, final judgment, cha-ching. After the final judgment, last important step here, take your final judgment, go to the clerk, ask for a writ of possession to be issued. They will hand you the form, sign off on the form, the clerk will sign off on the form, and then you pay them the fee, and then they will tell you to walk that over to the sheriff's office, and it's a signed copy of the writ of possession, and you have that, and you have your final judgment. You walk over to the sheriff's with your signed certified copies of the final judgment and writ of possession, which will be filed into the case as well. You walk it over to the sheriff's, you ask to schedule a time for a writ of possession to be executed, and then they will walk you through the process. And again, every county is a little bit different, so the specific sheriff's procedures here, for example, in St. Lucie County, they will either contact the lawyer, or if the lawyer puts on the writ letter with the check, you got to pay the $90 fee, at least in St. Lucie County, to have them execute the writ, and they'll call either the lawyer or the pro se defendant, or we'll just tell them, in order to speed things up, we'll just give them our client's information so that they can call the landlord or the property manager, whoever it is, and schedule a time to execute the writ of possession. So they'll do that. And last important step is that the sheriff will post a final 24 to 48 hour notice to the tenant being evicted saying, here's the copy of the writ of possession, here's your final eviction notice. If you're not out by 1 p.m. on this day, usually give them like 2 days or so, then we will be here to physically remove you. That's the eviction process. That's how to handle a tenant who is not paying in Florida. If you have any questions, give us a call. And again, time is money when it comes to evictions and the eviction process. And I highly recommend hiring an attorney, whether it's our firm or another firm, if you're trying to get people out quickly. If you only have 1 or 2 properties and you're trying to understand the business, maybe it will be good for you to go through the process yourself the first time. But there are important things that I've seen people make mistakes on, and it's really cost them. And in the long run, half the time they end up actually calling an attorney to handle it or to take up where they left off and finish out the eviction. So just bite the bullet, pay the $1,500, $2,500, however much the attorney's charging to do the eviction, pay it, get it done, and move on and put in a good tenant in your property. Well, if you stayed for that whole thing, congrats to you. I hope you learned something, and I hope you will subscribe and like our videos so that we can continue to help you guys out. And if you ever have questions, just give us a call. Thanks.